Sir, it has been 2 years since the India government came to power. What are the major achievements of this government in the field of law and justice?
We have taken several initiatives, several reforms in this department. Our Honorable Prime Minister's intention was access to justice should be made easier, and even all the individuals across the country, all the litigants, they should get the benefit. Ease of doing business is another area where he wanted to make India good destination for investors. Third, he wanted to have a speedy disposal of the cases, the huge pendency should be. The fourth one, he said that these obsolete laws that should be repealed. The statute book has to be cleared. Technology has to be brought in inside the whole judiciary so that the whole system should be very transparent and it should favor for the speedy disposal. These are the several areas that Honorable Prime Minister wanted, and accordingly the Ministry of Law and Justice taken initiation in all these areas.
Sir, one of the major steps taken by the India government was National Judicial Appointments Commission, and there was complete political consensus, near complete political consensus on the issue when the law was passed. But the Supreme Court has quashed this law as unconstitutional, and now the collegium system is back. We all know that collegium system is opaque. Even the Supreme Court admitted that it's an opaque system, and this memorandum of procedure for appointment of judges, that is still hanging fire. What are the sticking points so far as this particular issue is concerned?
At the very outset, I would like to say that, of course, this NJS has been struck down as it is unconstitutional and void. But the government had its reservation. We have placed on record in the Supreme Court that we have got reservation about the correctness of the judgment, and also stated the government reserves its liberty to take further action as it deems fit. That is one part. The second part, as you rightly asked, the memorandum of understanding was directed by the Supreme Court to submit it to the Chief Justice and the Collegium. Already after due consultation, after taking note of all the suggestions from various corners, the 4 areas wherein the draft memorandum procedure has to be looked into, that has been already submitted to the Honorable Chief Justice about a month back. We are awaiting the response from the Honorable Chief Justice.
So it's pending before the CJI and the
Yes,
Collegium?
it is pending before the CJI and the Collegium.
Sir, you said the government reserves the right to take appropriate measures so far as the collegium system is concerned, or the quashing of the NJAC is concerned. Attorney General Mr. Mukul Rohatgi also made similar statements. What are the options open for the government so far as NJAC is concerned?
See, practically a draft memorandum procedure which contains the memorandum, the procedures how the judges should be appointed will be there. So after due consultation, we have taken care of insertion of few areas wherein really the people of the country will feel it is a transparent, and the procedures that will be adopted will be right. And if there is any matters pertaining to any complaints and other things, how it should be taken care of, a separate secretariat to the appointments, all these things will be taken care of, and we have inserted everything and we have handed it over to the Chief Justice. Now it is in the domain of the Collegium, so they have to send it back. Then only we can say what do you mean by these reservations about the correctness of the judgment. Till then we can't say.
Sir, there are a large number of cases pending across various courts in India, and the CJI last month, he said there are 169 recommendations for appointment of judges in high courts that are pending with the government.
This is the major issue wherein there is some confusion with the people. Earlier, due to NJSC, it was challenged before the Supreme Court. We could not able to go for further appointments because only after the verdict comes out for about 6 or 7, 8, 9 months. But as soon as the Supreme Court gave the judgment, and as soon as Supreme Court directed the government to give a draft MOP, we thought that certainly there would be delay in finalizing the new MOP. I myself went to the Honorable Chief Justice and I told him, Honorable CJ, it will be delayed. So now we can go for the appointment as per the earlier memorandum procedure till the new memorandum procedure is finalized. Accordingly, I gave a letter to the Honorable Chief Justice and we started processing. You should wonder if you hear this. Last year, for the first 4 months up to April, 31 judges have been appointed, 2015. But after I went to the Chief Justice and I said that, sir, we can go ahead with the appointments as per the earlier memorandum procedure. This year, till today, we have appointed 51 new appointments and about 87 ad hoc judges made permanent. Just you see how, if I would have kept quiet, what would have been there was no appointment at all. The government took the initiative and we went there. And on that basis, now we have received about 170 names from the collegium. We are already processing it. See, as soon as the paper comes to us, we can't simply send it back. We have to send it to the Constitutional Authority, the Chief Minister of the state. He has to give his opinion. We have to send it to IB to collect the information about the credentials and other things of the new judge going to be appointed. So, without delay, we are doing it. I would like to place on record, this government received papers of appointment of new 4 judges to the Supreme Court. We have processed with 6 working days.
Yeah, I saw your tweet.
With 6 working days. We never used to keep it. But when there are certain confusions and other things, we used to process it in the manner which is required. So there is no delay on the part of the government at any point of time. It is the responsibility and duty of the collegium to send the names, to process the things. It is for the government.
The Law Commission of India recommended way back in 1987 that India should have better judge population ratio. It had recommended that India should have at least 50 judges per 10 lakh population. And CJI T.S. Thakur almost broke down while talking about this particular issue and the poor judge population ratio in India. Why has it not happened so far? Because thereafter there were judicial orders also to this effect.
Say 87, of course there was a report of the Law Commission. But the Law Commission never said that the judge population ratio is the only criteria for disposal of the cases and all that. And they said that there are no data wherein we can calculate this judge population ratio also at this stage. Only from the experts' opinion, some materials available outside, they said that yes, there should be more and more judges, but never said that it should be like this, it should be like this. But subsequently, Imtiaz Ahmad versus State of Uttar Pradesh, the Supreme Court itself referred the matter to the Law Commission to give a report. It is a very good, and the matter is still pending. I don't want to make further comments on that. But they said that there is no proper data available wherein judge population ratio should be there, and the workload should be the criteria for all these things. See, in certain states, for example, Meghalaya, Tripura, their case filing is very less. How we can have a judge population ratio for a separate state and here and there? So totally, of course, there are vacancies, I do concede. About 45% vacancies in the High Court, about 25% vacancies in subordinate courts, and in Supreme Court there are 2 vacancies at present. This I do concede. For this, government is not responsible. At any point, government never delayed. Why last year for 4 months only 31 names could be finalized? Why this year we could able to finalize 51 plus 87?
What you have said just now, it's a very interesting thing because the judiciary is talking about increasing the number of judges while the fact is that existing vacancies are not being filled. Who is responsible for
this
kind
I will tell you,
situation?
The increasing vacancies is by the government that we have to concur. We have to make all the benefits and other things, we have to do it. In High Courts, earlier the sanction strength was 906. We increased it by 25%. At present the sanction strength is 1065. The increase has been accepted by the various states and we are the persons to process it. So increase has been made by 25%. Not only here, even in subordinate courts, the increases has been made by 25%. Nearly 5,000 more judges. Earlier it was nearly 16,000 judicial officers were there. We have enhanced it to 20,502 at present. Earlier it was 17,775. So government has increased unless it is fulfilled. See, I will tell you, subordinate courts, the appointment should be made by the High Court and the state governments. It is their responsibilities. Central government cannot be pinpointed for the vacancies in the subordinate courts. The High Court and the state government has to fill up that. We have increased. In the High Court and Supreme Court, the collegium has to send the name. We have to fill it up.
So basically the delay, rather the vacancies are due to the functioning of the collegium system.
I will tell you, it is no delay is caused by the government side. That much I can say. I don't want to put anything on anybody.
Justice delayed is justice denied. That's an old saying. Judicial pendency in India has been a huge problem. And now more than 3 crore cases are pending across various courts in the country. It's becoming a huge problem that we cannot ignore. What are the steps the government has taken to deal with this issue?
We have taken several initiatives for disposal of the pending cases in courts. Practically, the disposal of cases is within the domain of the judiciary. Our government or the executive or the legislature at no point in time interfered in the activities of the judiciary. So it is executively within the domain of the judiciary. The timely disposal of the cases also depends on several factors. Not only that vacancy of judges. One, it includes the availability of the number of judges and supporting staff, physical infrastructure, category of the case or complexity of the facts involved, nature of evidence, cooperation of the stakeholders including bar, investigating agencies, witnesses and litigants, and the rules of procedures are all there. If advocate seeks 10 adjournments, automatically it will be delayed. But who has to curtail that adjournment? We did proper amendments to the Civil Procedure Code wherein it is said only 3 adjournments should be given. But average adjournments goes to 40 to 50 in various states. We have got all the statistics. So government cannot be blamed for the pendency of the cases.
How much repeal of laws has helped in the entire process or in handling the problem of judicial pendency?
Cleaning of the statute is the primary responsibility. See, dead laws will create confusion with the living laws. Yes. That is the saying. So Honorable Prime Minister Narendra Modi said, yes, our statute should be clear. Limited laws and maximum justice should be given to the people. 1,827 absolute laws are identified, out of which by repealing 4 bills and 4 acts have been so far taken, and nearly 1,175 acts have been repealed already. Prime Minister is telling that every day we should repeal 1, but it has exceeded 1.5. So we are going ahead with it. Out of 1,827, in and about 400 laws that need to be repealed by the states, because that laws was enacted here in the parliament during the precedence rules of the states. But after 42nd amendment, the state has to repeal it. Now 227, I hope so, the state has to do it. Rest about 400 odd that we have to repeal. I hope that within a short span of another 1 or 2 or 3 bills, we can repeal all these things. Repealing is also, it is not so easy. Immediately we can't. We send it to the nodal ministry, we get their consent, then we have to draft the repealing bills. But we are working on it day and night. We hope that repealing is one of the primary area concern of Honorable Prime Minister. We have taken care of positively.
Across the country, there is an e-court project which is going on, connecting all the courts through computer networks. How far this project has achieved its stated objectives?
Actually, use of technology is one of the prime concerns. Thereby we can have transparency, and even the case management systems could be done. And for litigants and lawyers, it will be easier to go through the case list and other things. So he can. So already first phase of the e-court project has been completed. More than 16,000 subordinate courts are already computerized. Now we are taking up the second phase of e-court project, that is at the cost of 1,670 crores. The cabinet has already approved and already the work have been started. We want to see that all the e-filing, e-payments and everything should be done through this process. Kiosks should be installed in various court complexes. There only they can make use of all these things. So we are working on it. 4 years time has been given to complete the project, but this government and Ministry of Law and Justice, we want to see that it should be completed by 3 years. So we are gearing up and we are speeding up the thing. We hope that at present nearly 6.76 crores or something like that. So much of cases, they have been already digitized, and nearly 2.6 crores pending, and disposed of cases, judgments are also available in the National Data Grid. We hope that after...
In digital form.
Digital form.
One of the controversial issues has been the post-retirement assignments to the judges. Do you think judges should accept post-retirement assignments?
The Constitution has made certain provisions wherein the post-retirement post in various areas should not be there. But there will be post-retirement positions that should be held by the for tribunals. We need some requirement law for certain commissions. The person who is well established with the law should be knowing this. But certain areas, the post-retirements, for example, CVC, for example, governors or something like that, few areas where they not be.
Cost of litigation has been a huge problem, and there are ways and means to deal with it because it's going up day by day. And often it's suggested that alternative disputes resolution mechanisms like arbitration, conciliation, mediation and lok adalats, they should be resorted to quite often. How far these measures have helped both in terms of dealing with the pendency and also making justice available to the common people at the minimum cost.
The alternative dispute resolution mechanism is one of the areas where we need to push up. For example, already you might have seen this Arbitration and Conciliation Act.
Latest.
Very stringent amendments have been brought to that act. So speedy disposal and all these things. Cost effective. For example, earlier the arbitrator's fee, it was fixed by the arbitrator according to his whims and fancy. Today it is not that. Either court should fix or both the parties, if they agree, they will fix up there only. Or else we had a fee schedule in the Arbitration Act itself so that they can't go beyond that. And early disposal, they will be given incentive. Delay in disposal, they will be penalized, their fees will be cut. All these things are there. Apart from that, that legal service authority, that is also giving a new dimension as far as these matters are concerned.
Talking about National Legal Services Authority,
yes,
State Legal Services
Authority, District Legal Service Authority, all these three authorities are giving certain things. Lok Adalat playing an important role nowadays. Lok Adalat, wherein we used to dispose of the cases even pre-litigation or the cases pending in the court, and
transferred to Lok Adalat.
Lok Adalats. And crores on crores cases have been disposed of through Lok Adalats. These are all once disposal, cost effective and user friendly. These are the three initiatives taken by our government.
Sir, you have completed 2 years of this government. 3 years are left for this government to complete. What are the major challenges before this government which you would like to deal with or accomplish?
Of course, we are going very fast. We have almost all completed what all assurances given by us to the people of the country. Nearly 50% we have completed within a short span of the year. But it doesn't mean there are no challenges. There are huge challenges before us. That Law Commission of India has submitted this 244 and 255th report with regard to the electoral reforms. This is a major issue in the country that we have to take care of. Entry of foreign lawyers. Today FDI and other things are coming. So we are investing something outside and all that. Chabbar Airport and all that. So all these things wherein there is a mutual reciprocity in foreign law firms, either in India or in the foreign countries. That is another area. Utilization of grants given by the 14th Finance Commission. Last year, 13th Finance Commission, we could not able to utilize the whole funds.
Most of the times, Supreme Court and various High Courts, they are not in a position to utilize the entire fund.
No, somewhere we should sit together and we should request, we should resolve the problems. That's a challenge what I am telling. So it doesn't mean that I am not putting the burden on anybody. Even enhancement of this ICT enabled courts, that is another area, very important area. Today, pendency, even disposal, all these things can be clearly looked at by this. Then filling up of vacancies, that has to be done. Only we are the cooperative partner from the other side. Reforming in court procedure and process, that is delaying the things, that is also looked into. Reduction of arrears and ensuring speedy trial. These are the several areas. Several challenges are before the Ministry of Law and Justice, and we hope that certainly, as per the direction of Honorable Prime Minister Narendra Modi ji, we will be able to reach up to the expectations of the people within another 3 years.
Thank you, sir, very much, and we all hope that you will accomplish all these tasks you just now narrated.
Thank you.